Good afternoon and welcome to the House Judiciary Committee. Call the committee to order. This is meeting number 3. And would our clerk please call the roll?
Representative Banta,
Here.
Representative Blanton, Representative Bratcher,
Here.
Representative Bray, Representative Burt,
Here.
Representative Dietz,
Here.
Representative Doan,
Present.
Representative Flannery,
Here.
Representative Herron,
Here.
Representative Colcarney,
Present.
Representative Lewis,
Here.
Representative Maddox,
Here.
Representative Mosier, Representative Nemus,
Here.
Representative Petrie,
Here.
Representative Rawlings,
Here.
Representative Sharp,
Present.
Representative Stevenson, Representative Wilson,
Here.
Co-Chair Decker,
Present.
Chairman Elliott.
I'm here. We have 6 bills for consideration, so a very ambitious agenda this afternoon. And the first bill that we're going to hear is House Bill 262, which is sponsored by Representative Flannery, an act relating to driving under the influence. And if you would come forward and Representative Flannery, introduce your guests and begin your presentation.
Ready to proceed, Mr. Chairman?
Yes, sir. You can proceed and introduce yourself, and
Patrick
your guests would
Flannery,
introduce
State
themselves.
Representative for the 96th District. I have with me 2 representatives from the County Attorneys Association. I will let them introduce themselves. They are at the table here. Also, here is Lewis Kelly, who is the Commonwealth's attorney in Boone County.
I'm Jenny Oldham. I'm the Hardin County Attorney and the President of the County Association.
And I'm Alan Ford, Woodford County Attorney and Treasurer for the Woodford County, or for the Kentucky County Attorneys Association.
Is your mic on, Mr. George? I think
Push it.
should turn green. So.
Alan George, Woodford County Attorney, Treasurer, Kentucky County Attorneys Association.
Thank you.
I would like the record to reflect I do have my smart water with me this morning, so I'm ready for some tough questions from this
There you go.
committee.
There you go.
This bill is 3 pages. It is in some regards a somewhat of a cleanup bill from House Bill 154 from last year that I sponsored and passed, but also has some new additions that are an attempt to respond to some situations that we often see in the criminal justice context. So starting on page 2, it inserts new language, standard operating procedures, and strikes manufacturer's instructions or instructions. There is a situation with an intoxilizer where there's a manufacturer that does not have instructions. I will let Mr. George explain that in more detail. So that attempts to clean that up and address that situation. We also have the second part of this starts on the bottom of page 2, rolls over to page 3, indicates that the mandatory detention on a DUI arrest will go from 4 hours to 6 hours, and that detainee who has been arrested as a suspect for driving under the influence would have to blow zeros to be released. This attempts to address situations where actually you have defendants that have been charged that are actually released from jail that still may be impaired at the time of their release. There are situations where upon release those persons have actually been involved in other motor vehicle wrecks, sometimes causing death or serious physical injury. So all that would do is simply state that they would have to indicate that they are not impaired by alcohol at the time. I will state that there will be a floor amendment. It was intended to be part of this committee sub. and is not, spoke with Representative Petrie about this yesterday. It was a simple oversight, but I do want to make it clear that the floor amendment will state that this subsequent test cannot be used as evidence in the prosecution. Personally, I don't think that it's relevant, but if there is an issue on that, that floor amendment will clean that language up and address that situation. And last, on page 3, I believe for the first time in Kentucky, this would create, if passed, a vehicular homicide statute, which would be a Class B felony. Currently, prosecutors are faced with a situation when they have a DUI that results in the death of someone. They can charge Class A wanton murder, which may be difficult to prove, or they can go Class C man 2, or a Class D, I believe reckless homicide. So this really fills the gap, and it would be what we would call a strict liability crime, but I think it really fills the gap and fits something that's needed in our KRS laws on driving under the influence. Be glad to let Mr. George, to my right, explain, I guess, what we're dealing with on the standard operating procedures and why that's necessary to have this included.
If I may,
Yes, you may.
thank you. I think we have to go back to 1991 when this legislature adopted 189A 300, which requires the state to furnish, I'll call them intoxilizers, for every county in Kentucky at state cost. That was the, in effect, enabling legislation that made it where every county would have an intoxilizer. At that time, they were called breathalyzers, and over time they renamed to intoxilizers. Early versions of that did have an operator's instruction manual. The later versions did not. I am not clear when the legislature made it a requirement that manufacturers' instructions be referenced and adhered to in breath testing, but it became evident that it's now a matter of impossibility of performance for us as prosecutors to establish that it was done according to those instructions because they don't exist. Some judges are saying, therefore, we're going to suppress these results, and that critically hampers our cases across the Commonwealth.
Motion on the bill, Mr. Chairman.
I believe, Mr. Chairman, we do have a committee
There's a
sub.
committee sub, so I would entertain a motion to adopt the committee sub.
Second.
So there's a motion by Representative Sharp and a second by Representative Nemus to adopt the sub. All those in favor, please say aye. Aye. Those opposed, no. And the committee sub is adopted. Now I think I'll entertain a motion on the bill as amended by the sub
So moved.
for adoption. A motion by Representative Nemus, second by Representative Sharp. Secretary, please call the roll. Are there questions?
Yeah, one if I may.
There is one, okay. Representative Petrie.
Yeah, thank you, Mr. Chairman, and Representative Flannery. Thank you for talking to me about this bill yesterday. I think the amendment you're talking about will meet that, and I think the discussion about the need for the instructions, the standards as opposed to the instructions for the machines, good. Separate question, just asking if you have it. I know that we're going up to 6 hours from 4 hours on page 3, that line 1. Is what data and analysis do we have that says going from 4 to 6 is warranted as opposed to 4 to 5, 4 to 7, 4 to 8? If it's anecdote, that's fine. I'm not really interested in that, but I wonder if there's any data or analysis that says why we're moving to a particular different number, please.
I'll address that. I don't have any specific data. That's just really more of a personal judgment call based upon anecdotal evidence and based upon the fact that hopefully that additional 2 hours will give someone in the proverbial drunk tank the opportunity to sober up, and it's really more of an issue to just be sure when they are released that they will not continue to be a harm to anyone on the public roadways. But I do have anecdotal evidence from practicing law, talking to persons that are jailers and other people that sometimes, persons are released that still may be impaired.
Thank you. There's a motion and a second, and I don't think there's any more discussion, so. Representative Wilson, you're recognized.
I just have one question. If a zero is required to get out of jail, what happens in the case of a refusal when you see that sometimes they just refuse to take a intoxicizers test?
Yeah,
Are
great.
they in jail until they see a judge?
I believe that should be covered in that, but that kind of goes back to the other issue of the floor amendment will address that. That can't be used to against the defendant. I don't think that's fair, and that's really, in my opinion, not relevant to the underlying charge, but that's why it was intended for that to be addressed more clearly in this committee sub, but making a rush to make sure we got within the 24-hour rule that erroneously excluded. Mr. George, you have anything else you'd like to say?
I believe that's addressed in effect when it references any person who is arrested for violation of the subsection B would be standard driving under the influence with no number, which would typically be a refusal. And so it's addressed in that fact.
And if I could, that new language that will let you maintain your refusal and take this portable breath test for the release issue, those would be two different issues.
Thank you. So I think our roll call can begin.
Representative Banta,
Yes.
Representative Blanton, Representative Bratcher,
Yes.
Representative Bray, Representative Burke,
Yes.
Representative Decker,
Yes.
Representative Dietz,
Yes.
Representative Doan,
Yes.
Representative Flannery,
Yes.
Representative Herron,
Pass.
Representative Kulkarni.
Briefly explain my vote.
Yes, you may.
Mr. Chairman, thank you. I'm going to pass today. I just want to get a handle on the floor amendment that you'd mentioned, before, what exactly it does, and just study this a little bit further and maybe ask you a couple of questions because we are creating an entirely new offense. Is that correct? In the Okay, thank you. So sorry, I'm a pass for today. Thank you.
Representative Lewis,
Yes.
Representative Maddox,
Yes.
Representative Mosier,
Yes.
Representative Nemus,
Yes.
Representative Petrie,
Yes.
Representative Rawlings,
Yes.
Representative Sharp,
Aye.
Representative Stevenson, Representative Wilson,
Yes.
Chairman Elliott,
Aye.
Representative Bray,
Yes. With 17 yes votes, 0 no votes, and 3 pass votes, House Bill 262 with House Committee substitute is passed and will be reported with favorable expression that the same should pass. There is a title amendment. Is there a motion to adopt the title amendment?
So moved.
Motion by Representative Petrie. Is there a second? Second to adopt the title amendment.
Second.
Second by Representative Doan. All in favor, please say aye. Aye, and those opposed, no. And the title amendment is adopted. Right. Let's see. Thank you, Representative. I'm going to take up. Get my agenda here. Okay. The next bill we will take up is House Bill 353, Representative Kimberly Poor Mosier, an act relating to drug paraphernalia. Do we have anybody? Okay. And if you would, is she bringing them to the table? Good, wonderful. So if you would introduce yourselves for the record and your guests, and then you can proceed. Thank you.
Thank you very much, Mr. Chair, and thank you to the committee for hearing this bill. House Bill 353 does have a committee sub.
A motion by Representative Doan and a and a second by Representative Petrie to adopt the sub. All those in favor, please say aye. Aye. Those opposed, no, and the sub is adopted. So you can proceed.
Thank you so much. So I'll go ahead and just speak to the bill as amended by the committee sub. All this bill does is removes fentanyl test strips from the statute around paraphernalia. We feel that this is important, and I should say I've got some esteemed guests with me, so maybe I should go ahead and let them introduce themselves for the
Yes,
record before
that's
we
great.
go ahead. Thank you.
Well, when you say esteemed, I got to look on the other side of you and defer to this nice lady here to introduce herself.
My name is Sydney Romo. I am a resident of Shelby County.
Okay, thank you, Sydney.
My name is Brian Hubbard. I am the Chair and Executive Director of the Kentucky Opioid Abatement Advisory Commission.
Okay, thank you. And we do have others on hand to speak to this bill and certainly answer questions if we should have any. As you heard, we have support from the Attorney General's office, the Chiefs of Police, the Commonwealth Attorneys, and the ACLU, Dream.org, and the Bluegrass Institute. This has broad support.
On the bill by Representative Petrie, is there a second? Second by Representative Doan. Is there any discussion? And we do have some folks who I know you have asked to present today, so I would yield to you to have some time if they would like to
Okay.
have a few words.
Thank you. I think
I'll leave that up to you.
Yeah, thank you so much, Mr. Chair. I think that would be really good because I think this is an important issue that we really should have a little bit of discussion about and just educating folks on the importance of this. So if I could have Mr. Hubbard go ahead.
Thank you, Representative Moser, for asking me to be up here with you. And Mr. Chairman, if I might, I would just like to read a letter that has been composed today for this very event. Representative Moser, over the past several months, the Kentucky Opioid Abatement Advisory Commission has conducted 11 town halls from Pikeville to Paducah for the purpose of engaging Kentuckians in strategic discussions as to how to best fight the opioid epidemic over the coming years. On February 1, 2023, you kindly participated in the debut of Operation Fight Fentanyl, which is my personal initiative to take on the devastating effects of fentanyl infiltration into every Kentucky county, city, and town. As you well know, fentanyl and other lethal chemical agents pose an existential threat to anyone who may come into contact with them. Given the insidious introduction of fentanyl and other chemical agents into the illicit drug supply chains, the risk of unintentional exposure to these agents is extraordinarily high. In order to equip Kentuckians with the necessary tools to prevent accidental, lethal chemical exposure, whether they be individuals affected by substance use disorder or first responders who are dedicated to interdicting harm, I wish to express support for House Bill 353. Your work on this bill demonstrates your thoughtful and concrete response to prevailing conditions throughout the Commonwealth. Please let me know how I may be of further assistance to you on this critical issue. Thank you for your leadership, Attorney General Daniel Cameron, co-signed by me.
Thank you very much. That's very kind. Thank you. And I appreciate the work that the Attorney General has done on this issue as well. We know that
So, as I said, my name is Sydney Romo. I am a resident of Shelby County. I am here to be a voice for my nephew, Parker Ryan. His mother is unable to be here today, so as I said, I will be the voice for our family. Parker was born on November 4th, 2004. He was a beautiful baby boy born into a generational curse of addiction. He was the only boy in our family for over a decade. Parker was full of life. He was funny, full of energy. From a very young age, he began climbing on things, refrigerators, cabinets. He was such a boy. Anything he could possibly do, he could get into. He was wild. Parker was raised by his grandfather and his grandmother for most of his life. They were given unconditional love to him. Although he was surrounded by love, he had to grow up with what should have been the most important person in his life, which was his mother. And she was unable to do that due to her being an addict as well. As an addict, she was in and out of his life. She wasn't able to be there when he had a bad day at school, or to help him grow up, help him with his homework, or have a talk with him just as a mom. This caused a lot of issues within him. He became very angry, and he started acting out in school. He surrounded himself with kids that struggled with the same issues as him because it was so relatable. Parker's grandfather did the best he could to teach him from right and wrong and get him the help that he needed, but nothing seemed to work. His grandfather passed away in 2018 from a long battle with cancer. They were truly best friends. As a child, Parker watched the man who raised him slowly fade away. It was a tragic event that pushed Parker to his breaking point. He was experimenting with pills to numb his pain. The night he died, he thought he would take this little tiny pill to go to sleep and get up and go to school the next day, but he never woke up. The pill contained a lethal dose of fentanyl. Parker was only 17 years old. Had Parker been educated about the facts of fentanyl and had testing strips in his possession, or had been educated, that would have changed his opinion on taking that pill that night. Fentanyl is everywhere from metropolitan areas to rural areas. Fentanyl does not discriminate, and no matter what family an addict comes from, it could potentially affect any of you sitting here today. Parker's mother, which is my sister, got clean on January 2022. Parker is not here to see that. She will never get to hold him. She will never get to get that relationship with him as a mother. And he will never get to see how she overcame her addiction like she wanted to help him. What we can do today is fight to potentially save another family. We do not want to see anybody endure on a daily basis the suffering that my family has. As a voice for my nephew, I plan to spread awareness about the lethal drug and do anything I can to possibly save another child's life. Had fentanyl testing strips been available in education programs about the dangers of fentanyl, perhaps he'd be alive today. Too many families are affected by loved ones struggling with addiction. Let's get together and do everything we can in our power to save lives. I ask that you vote yes on HB 353. This time it was my nephew. I hope that next time it's not one of your loved ones. Thank you for letting me share a glimpse of my nephew's life.
Thank you for your testimony, and our heart goes out to you. Is there any discussion on the matter? Don't believe so. Secretary, please call the roll. Yeah. Secretary, please call the roll.
Representative Banta,
Yes.
Representative Blanton, Representative Bratcher,
Yes.
Representative Bray,
Yes.
Representative Burke,
Yes.
Representative Decker,
Yes, explain my vote.
Yes, you may.
I want to thank you for coming here today as your state representative. I want you to know how important it is that we hear from people like you. It takes courage, it takes strength. Thank you for your testimony. Our heart goes out to you.
Representative Dietz,
Yes.
Representative Doan,
Yes.
Representative Flannery, Representative Herron,
Yes.
Representative Kulkarni,
Yes.
Representative Lewis,
Yes.
Representative Maddox,
Yes.
Representative Mosier,
Yes.
Representative Nemes,
Yes.
Representative Petrie,
Yes.
Representative Rawlings,
Yes.
Representative Sharp,
Aye.
Representative Stevenson,
Yes.
Representative Wilson,
Yes.
Chairman Elliott.
Aye. With 19 yes votes and no votes, House Bill 353 passes as amended by the committee substitute and will be reported with favorable expression that same should pass. Thank you very much for your
Thank you,
bringing this
Mr.
bill.
Chair. Thank you, committee.
The next item that we will hear for discussion only is House Bill 463, which is an act relating to child support and declaring an emergency. And I know we have several distinguished guests with us that we need to, from out of state and otherwise, that we'd like to advance. So I'll turn the meeting over to my co-chair.
All I say is to go forward. And thank you.
Right, absolutely. Yeah. Thank you. Let's see, I need to take the right stuff down with me. Thank
Mhm. Yes. I would still refer to him as Representative Massey, don't you? That's fine. Or chair can see or whatever. Thank you, Mr. Chairman. You may proceed.
Thank you, Madam Chairman. It's an honor to be here today with my distinguished guests. I'm Daniel Elliott. I'm the state representative of the 54th District, and I'll let my guests introduce themselves. Turn your microphone on.
Good morning, close to afternoon, I guess. I'm Lucinda Masterton. I just retired as a family court judge in Fayette County, and for many years, I was the chair of the Child Support Guidelines Commission, which is, I think, why I'm here.
Yeah. Good afternoon. I'm Ed Massey. I've worked on this for about 3 years, so I'm happy to bring some light to it if I can.
Well, thank you, Madam Chairman and members of the committee. Our objective in this was to do what is in the best interests of Kentucky children and families, and to develop a shared parenting time adjustment that would be congruent with a recently adopted Kentucky statute, probably not so recent, but at the time recent, that provides a rebuttable presumption of equal time sharing or equal parenting time. And this shared parenting time adjustment should yield consistent order amounts in shared parenting time situations, provide predictable amounts for divorcing and separating parents, and be simple to use and minimize litigation. And so I'm going to turn this over to my distinguished guests to go through what they would like to talk about, and then we can go through the bill specifically. I know we also have some guests. Is Zoom working? And we have some, and I don't know if we need to give them an opportunity to introduce themselves on Zoom as well, just to know that they're there, but we have some judges from out of state that are joining us. So
Why don't we do that? If Dr. Venor could introduce herself for the record.
Thank you, Madam Chair. I'm Dr. Jane Venor. I'm an economist that helped the committee with the child support guidelines schedule update and the time sharing adjustment.
Thank you. And Kate Richardson, if you could introduce yourself for the record, please.
Yes, thank you. Thank you, Madam Chair, members of the committee. My name is Kay Cooper Richardson. I am the director of the Oregon Child Support Program and worked with this committee on a similar provision in Oregon's guidelines.
Thank you. You may proceed.
Thank you. This process began actually 4 years ago. We were given the directive that we needed to change the child support schedules, because if we didn't, we were going to lose federal funding. And so we set about doing that, and we did that, and that received great remarks from our colleagues around the state. After that, we decided we need to deal with this issue about parenting time credit, because whether we like it or not, there's a case that basically says that there's a presumption of shared parenting. And there's also a statutory provision to that effect. So what happens is when you start with that as your baseline, there has to be some accommodation of credit when the child support is computed, so that a person, based on the overnights, et cetera, will get a reciprocal credit for the time that they actually had the child. And we try to really get down in the weeds on this, because it's not a matter of just an overnight, because if a child stays with the parent and goes there at 9 o'clock and goes to bed and gets up and leaves at 6 and goes to school, you know, that really doesn't go towards the the heart of what we're trying to accommodate as far as who's caring for the child, who's providing, etc. So we set about this, and the reason I have Judge Masterton, I asked her to be here, is because this had been worked on even prior to that 4-year period, and there was some confusion that happened in our very first meeting where she kept talking about Dr. Venor. And I said, well, we also have used a Dr. Venor, and things had transcended during that time, so we had to get on the same wavelength so that we're talking about the same thing. So Dr. Venor that's here is a renowned expert across our nation in child support, and she's been working with us through this process. For those attorneys in the room, you know, there's the Colorado rule, there's the Arizona rule, there's the Oregon rule, there's the Oregon-Arizona rule. And we wanted to set about to create what we do here in Kentucky. And so we looked at those variety of models. We talked with many judges. We had judges on the committee. We had discussions with several judges. There's some concern by anyone when there's a change in the process, and the biggest concern was that it was going to become so complicated and so difficult that it would be very difficult for judges, child support, county attorneys, and for lawyers to basically compute these things in a timely, quick manner. And that was a problem, and we understood that because our goal was that we did not want to confuse the process. We wanted to simplify the process. And if you'll remember, we passed, when I was part of the legislature, we passed a bill allowing the Child Support Office to create a manual that would help show how this was going to be done efficiently and timely and easily for purposes of computation. So in the past year, and I worked on this up until December when I left the legislature, we had meetings monthly, and we went through this, and we worked with the drafter. We worked with Judge Masterton. We worked with Lexington Sowers, who's the drafter that has now left us and gone on to another horizon. We've worked with Steve Vino, who's here in the room with us today. We worked with his assistant Lily, who's in the room with us here today. And putting this all together, this bill reflects what that group came up with as the best solution to deal with this issue. It needs to be dealt with because right now it can be dealt with differently in counties across the state. So some will use the Colorado method, some use another method, and judges have wide discretion, as we know, especially family law judges, as far as they implement that into their courtrooms. And part of the issue, in my area at least, is that you might have judges in the same courthouse that apply it differently. You might have judges that are across counties, but they're adjoining counties that apply it differently. So our goal was to create a systemic process that allows this to be applied equitably and accurately through the state. So that's the basis of the bill. Again, this has been the reason we had it last year. If you remember, we actually repealed a portion of the bill and set it forward. So we need to act on something within this legislative cycle in order to make this work with the child support tables that have already been authorized. So with that, I'll turn it over to Judge Masterton, who's been part of this process as well, and let her comment.
I didn't bring any prepared comments. I'm thrilled to be here. I'm thrilled that we're really coming up with something. And mostly what I am happy about is that the committee has continued to work with Dr. Venor, because when I was chair of the commission, one of the frustrations that we had was we really didn't understand it as well as we should have. And Dr. Venor brought a tremendous amount of expertise to this topic. When I left, we had proposed the Oregon formula, which the commission really approved of. This is a different idea. Well, it's a different formula, but it's the same idea, which is that you have gradual adjustments. And I think we could still have plenty of debate about whether this is perfect, but I guess my message is that I prefer that pretty darn good not succumb to perfection as a goal. And nobody can describe what perfection is anyway. So I believe that we have, through this process, come up with a formula that is workable. I really believe the major danger that we have been saddled with forever is that judges couldn't get on the same page. And the whole idea of child support guidelines is to simplify and develop consistency across the state so that it doesn't matter whether you live in Louisville or in Pikeville, the formula will be the same. And that's what this bill accomplishes. That's the major, in my view, benefit to this bill. It also is pretty easy to figure out. We'll get some worksheets that will work, I think. And so bottom line, I thank Dr. Venor for her expertise, and I thank the work of Representative Massey and everyone else who's worked on this project. I'm happy to say I think we've gotten a pretty darn good result here.
One thing I did neglect to mention in my comments was the fact that there was a big concern that there was going to be this barrage of litigation if we do this change. That was a real concern, that it was just going to open the floodgates of litigation, and people were going to be in court, and the judges were going to be more overwhelmed than they already are. And I know Representative Dietz and I both practice in Northern Kentucky, and it's not uncommon, it wasn't uncommon to go to Boone County and be there till 8 p.m. at night trying to deal with cases. And that's because of the large onslaught of things that they have to deal with. But I will say that we've talked with the people in Oregon, we've talked with the people in Arizona, and both of them said that it was a nil effect. There was really not a barrage of litigation, that there was initially some trainings that had to be done to bring people up to speed, and that is part of the manual process that this body passed last year, and there will be some trainings that will be involved with judges, with county attorneys, and with practitioners. And the goal, again, is to get us all on the same page.
Well, thank you very much, and I would yield to Dr. Venor if she has any additional comments. I know she's on.
Madam Chair, is it okay if I speak? I wasn't sure if that
Yes,
was
please.
an invite.
Yes, please.
Oh, thank you. Thank you for all the kudos, but I really do have to throw it back on the people of Kentucky. You know, this was very much a group effort in 2 years where they've done their homework as far as looking at all other state guidelines, as far as their time sharing. Ms. Richardson from Oregon's on this call. Fortunately, the judges from Arizona that have been talking to Kentucky folks, both the legislator, the judges, the commission members, the cabinet on health and family services, Lily Patterson. I mean, they've all done a lot of work to really research and talk to attorneys. As far as my role, I just came up with a formula that was made sense based on other states and based on parenting time guidelines in various Kentucky jurisdictions. And I'm going to stop there, and I'll be available for questions.
Ms. Richardson, would you like to address the committee?
Thank you, Madam Chair. Just briefly, we were very happy to work with Kentucky to discuss this issue because in our guidelines review some years ago, we addressed the very issue regarding a lot of litigation around the what we call the cliff effect, where there was no parenting time credit given for persons with just a very little amount of time. And in the end, there was a lot of litigation about how many overnights here and there. We were able in our guidelines to find a solution that was very incremental and was able to achieve, and I will underscore this, that it removed the argument and the litigation regarding parenting time credits and that parenting time, because it was so incremental that one day here or another night there did not make a significant difference, but it also honored the parenting time that was shared between both parents and recognized the value of that. So I just wanted to say that we were happy to share this model, and we've been able to do that with some other states. We are entering our own guidelines review again right now, but I will tell you that this matter we believe is resolved and has played out over the last several years, that we have solved a problem that we had before, and we will be continuing with this model going forward. Thank you.
Thank you. We have some questions, and I will call on Representative Moser.
Thank you, Madam Chair. And thank you for coming today. I understand that you've done a great deal of work, but can you very succinctly, I mean, I'm not a lawyer, and I don't practice family law. Can you very succinctly tell us what the problem is that we're solving here and exactly how this addresses it?
So the problem is that now that we have new child support tables, and we have those figures in place, and we have this presumption, whether we like it or not, that there's shared parenting, that if there's shared parenting, it's never 50-50. It cannot be 50-50 because unless both parents are so wealthy that they don't have to work and they can do week on, week off, or something of that nature, they have to work around their job schedules. So what's happened in some cases is that some people are getting inappropriate credit because they really don't have the child, maybe except overnight. And then some aren't getting enough credit because they actually have the child more than what is reflected in their agreement or their agreed order. So on the bill on page 3 of 35, it's a long bill, you can see the language in there specifically at the bottom, starting at line 17 through line 25. It shows the parenting time days, and then it shows the adjustment percentage. And the reason that's in there like that is to eliminate that cliff effect that they were talking about, where one night, in essence, could make a huge difference in the child support computation. That is not the intent here, because if that were the case, it would create that litigation event, because everybody would run in. If they got one more night, they would run back in and file litigation trying to get that offset on their child support. So the incremental increase, which is what is tried to be accomplished here, allows some very small changes. So there would have to be a substantial increase in time in order to change that computation or that formula. So that's what we're trying to solve.
Okay, thank you.
Representative Doan? Oh, Dietz. Dietz is next. I'm sorry.
Thank you, Madam Chair, and thank you for being here today. So as background, I'm a family law attorney, have been for 29, 30 years, and I think the judge, I took training under you for my mediation. I appreciate all the hard work you all put into this. I have some concerns, which I have voiced to Chair Elliott, and I also know since I'm new, I'm 6 months behind. So with that being said, I have concerns. We're not Oregon and we're not Arizona. We're the Commonwealth of Kentucky. I don't know how their courts are organized. I can tell you that in Northern Kentucky, and since we are now in family court, we've added a new judge. We've had elections. We have new judges in all our counties. They're pushing we'll just set this for 15 minutes, come back. We're going to set this for 15 minutes, come back. So we have problems gaining access to the courts still, I think. And I raise that issue because I think what this does is it could promote litigation, and I heard everything you all said. Parents fight over what does an overnight mean? What does it mean if I have them for dinner? What does it mean if I'm helping the other parent out and I'm picking them up and I'm running them to their select baseball game and I've got to get a hotel overnight? There are so many things that go into creating a parenting schedule. I have the benefit of being a mediator, part of the collaborative family law group, so not just litigation, but we spend a lot of time on parenting plans. And I fear that when we are tying this to a percentage, that it's going to increase litigation or decrease the ability for people to be able to reach agreements on their own, which is what we should want as family law practitioners, so that we can help their relationship as they go forward as divorced couples. That's always my goal with a couple. I don't want to increase that. So that's a concern for me. And that we're also getting rid of that flexibility that we want to encourage, where the parents can say, can you help me out? And then we're tying it to this number. So you all have said this is pretty easy. There's been other comments about a manual and trainings. And I heard this before I came here,
And when I hear that we have to have trainings and a manual to learn to run a child support worksheet that I should be able to do in front of my client in 60 seconds when they're in my office for a consultation, causes me heartburn. I'm also concerned that the county attorneys are going to get into the practice then of creating parenting schedules, because my clients, I give them the option when they call and say, I think that he bought a new car. He must have more money. Well, go to the child support office. They can run the numbers for free, then come back to me if you're not satisfied. The county attorney can't get into parenting time. That's not part of their job. Their job is to run the numbers. And I don't speak for the county attorneys, but I would think that if they have W-2 employees, it's a much easier job for them. Now that we're going to tie parenting time to their job, they're going to be sending all these people back to their private practitioners. And so I think it's going to increase costs for our citizens that normally go back and they can work with the county attorney. So those are just some of my concerns. The last thing I'll say is I also have the honor that I'm a fellow in the American Academy of Matrimonial Lawyers. I did reach out to our chapter in Kentucky, and I don't speak for them, but I can tell you the emails I got back, they were the same concerns I had, is that this is going to increase litigation and is going to decrease our ability to be able to work through agreements without going to court. Thank you.
If we could be concise with any responses you have, we still have 4 bills left with 45 minutes of time. Thank you.
I'll be very concise. The day, actually on page 1, the definition of his day is set forth in lines 5 through 19. And so again, that was considered. I just wanted the committee to be aware of that.
Could I just make one comment about that?
Please be brief. Thank you.
I will try. Way back when we were considering the Oregon formula, I reached out to members of the AAML in Oregon to see, because that was my fear too, that whatever we did was going to create more litigation. And the message I got, and I didn't poll all of them, but just randomly, if you talk to a few, and the message I got was that almost immediately litigation went away. And I think because you have a gradual adjustment rather than a cliff, the incremental change is so small, almost regardless of how you define a day, that it's not going to promote litigation. So I felt comfortable based on those conversations. I understand that I've heard the same comments that people are concerned about defining a day, but we have to figure out some way to have an adjustment. Otherwise, what we have now is just unworkable.
Thank you. Representative Doan.
Thank you. I have some comments on this bill. It needs work. At the bottom of page 3, lines 26 and 27, we say that failure for one party to consistently comply with a parenting schedule shall be grounds for the other party to seek modification for the court. This bill does nothing to define what consistently comply means. Now, I do understand that above there is a schedule which alters the days, and you may make an inference there. But without a definition, it leaves it into my hands as a family law attorney to decide whether or not I want to file a motion and bring that other party into court. It's a discretionary issue that certainly needs some work. So in some ways, this bill does tend to increase the potential for litigation. And in another very critical way, it absolutely abolishes any ability for some people to go in and to get relief. Our Supreme Court recently considered the case of McCarthy v. Fareed. Kenneth Fareed was an NBA basketball player. He made millions of dollars. The primary purpose of child support is to put that child in the same position regardless of which parent they're with. So in the Supreme Court in that case said, certainly our guidelines end at a point, but that doesn't mean that child support ends. Child support continues based on the income of the parents. At the top of page 4 on the bill that we've been provided with, it says a party may seek modification following a 15% change in the number of time-sharing days. That's essentially the same as our current statute. If the sentence ended there, I wouldn't have a problem. Afterward, it says, and shall have the burden of proving a material change in time-sharing circumstances. One party's income could change by $1 million, and the other party could not come in to modify child support unless time sharing changed, which once people have resolved and figured out and gotten to equal parenting time, it's not going to change. So there are some serious issues that need to be addressed in that area that ultimately we're going to put children in worse off situations if we don't. Thank you.
Thank you. Anything further, Mr. Chairman?
I don't have anything further. I
Thank you.
my guests for being here.
No, I just want to point out that Steve Vino and Lily Patterson are here in the room. I would certainly encourage any member of this committee to talk to them. They can explain a lot of the things that were raised. I will tell you that we've worked on this every month for 2 years. There will never be a perfect bill. I've heard it said committee after committee meeting. This will require work in the future, as all bills do. And that's why the committees have the ability to repeal, pass, et cetera. So I would just encourage you to talk to the people that are the true experts, which would be Lily Patterson, Steve Vino, Dr. Venor. They certainly have access to her, so they'll answer any questions you may have.
Thank you.
Thank you.
Thanks, Judge.
What's next? Is she here? No, she's here. What is the number? It's House Bill 369. I'll let him do that.
Yes. We are going to hear House Bill 369. Representative Suzanne Miles, if she will come forward. You may begin. I think you're now an honorary member of our committee, Representative Miles.
Thank you, Mr. Chairman, and thank you for the opportunity to be in front of you all today, in front of the committee. There is a committee substitute.
And there's a motion. Who had the motion? Representative Lewis, and a second by Representative Bray. All those in favor, please say aye. Aye. Those opposed, no. And the committee sub is adopted, and you may proceed.
Thank you. I'm hopeful this is one of the smallest bills you all encounter this session, is my goal. There is on the first page, we do change the word from a series of to multiple is the main meat of this bill. And this came specifically from an employer that contacted me with the concern of the opportunity for him having an employee that was having difficulty getting expungements because of the crimes that he had committed in the past. That he had felonies at a very young age, and several years later, the circumstances coming about for him to try to get an expungement, he was told that he could only have one expungement per felony. His specific item was due to cold checks, and there were multiple cold checks. And my understanding is kind of the interpretation of the judges and the courts and things like that, whether or not they can have one felony expunged or if they could have multiple. So that was with the change of that. We also, if you go further back into the bill on page 4, at the time that we did some of the expungement work in 2019, it put where you could only have one expungement beyond that time period. And so we have stricken that so that you would have the opportunity to apply for multiple expungements. And the main thing that comes out of hopefully this bill, the opportunity for more of our people that have a felony on their record, multiple felonies, that this changed nothing about their charges. This changes nothing about their time period before they could apply for expungement, anything like that.
There's a motion by Representative Moser, a second by Representative Nemus. Is there any discussion? And if not, would our secretary please call the roll?
Representative Banta.
Yes.
Representative Blanton. Representative Bratcher.
Yes.
Representative Bray.
Yes.
Representative Byrd.
Yes.
Representative Decker.
Yes.
Representative Dietz.
Yes.
Representative Doan.
Yes.
Representative Flannery.
Yes.
Representative Herron. Representative Colcarney.
Yes.
Representative Lewis.
Yes.
Representative Maddox.
Yes.
Representative Mosier.
Yes.
Representative Nemus.
Yes.
Representative Petrie.
Yes.
Representative Rawlings.
Yes.
Representative Sharp.
Aye.
Representative Stevenson.
Yes.
Representative Wilson.
Yes.
Chairman Elliott.
Aye. With 19 yes votes and no votes and no pass votes, House Bill 369 with committee substitute is approved by the committee and same should pass to the floor. So congratulations.
Thank you, Mr. Chairman, and thank you, committee.
Thank you. Next, we will hear House Bill 568, which is Representative Jason Nemus, an act relating to the public defender system. And if you would make your way to the table, Representative Nemus, and introduce your guests.
Thank you,
You
Mr.
may
Chairman.
proceed.
I have two guests. All right. The second one will be walking in. I'm Representative Jason Nemus. I represent the 33rd House District, Jefferson, Oldham, Shelby counties.
I'm Ed Monahan. I'm a former public advocate of Kentucky.
Good afternoon. My name is Ernie Lewis. I was the public advocate from 1996 until 2008.
Thank you, Mr. Chairman. What we're going to do is I'm going to say about a sentence about what the bill does, and then I'm going to turn it over to these gentlemen who will give a very brief history of DPA, which I think is important to the question, and then I'll close in a sentence or two, and then we'll be ready to roll. In a sentence, what this bill does is it brings the Louisville Public Advocacy Office under the umbrella of the state system. There are currently no offices except for Louisville's that is outside the state system, and as we're going to hear right now, it's time to bring Louisville's under the state's umbrella. So, Mr. Lewis.
Yes, I'm going to be very brief, and I'm going to talk about the context for this bill, starting with 1963, when the obligation for providing counsel to poor people charged with a crime was imposed on the state in Gideon versus Wainwright. At that time in Kentucky, they complied with Gideon by requiring lawyers to provide pro bono services to poor people charged with crimes. In 1972, this General Assembly passed KRS Chapter 31, which created the Office of Public Defender, now known as the Department of Public Advocacy. From 1972 until 1982, counsel was provided, and counties had a responsibility for funding counsel, even though it was a state responsibility. In 1982, the Public Advocacy Commission was created, and this General Assembly at the same time eliminated the assigned counsel plan. Gradually, from 1982 until 1996, counties dropped out like flies. They could not afford to pay for the state responsibility. When I was appointed by Governor Patton in 1996, 47 counties were full-time, covering those counties that had dropped out, and 73 counties were still using what was called a plan. And a plan was something the county was following to provide funding for public defender services. The Public Advocacy Commission in 1992 set out a complete full-time system as their primary goal. So in 1996, when I was appointed, I tried to implement that goal. That goal was completed in 2005, whereby all the counties in Kentucky were covered by a full-time system. I think it was 31 offices by that point. By 2005, only 2 counties were not in the state system where there were full-time state employees providing services, and that was Fayette and Jefferson. In 2007, Fayette County converted from a locally funded, locally operated full-time office to a state office, leaving only Jefferson County. Jefferson County remained outside the state system from 2007, and glaringly so, I would add. This bill cleans that up, brings Jefferson County into the system, and I think it's a great bill, and thank Representative Nemes for this.
I was public advocate from 2008 to 2017, and I am here strongly supporting this bill because during my tenure, I had many conversations with the then executive director of the Louisville Public Defender Office, and the conversations were about the inevitability of them coming in as the last county when the time was right. The great thing about this bill is it is a state obligation. This will allow every public defender providing representation in the state of Kentucky to be on equal footing in terms of salary and benefits, and to have a unified structure that will promote the effectiveness of the system in terms of representing clients competently, and it will increase the efficiencies with a single public advocate having the ability to use the resources that you give him most efficiently.
Thank you, Mr. Chairman. Let me say that I used to be, as everyone knows, the director of the Administrative Office of Courts, was what I was when the Fayette County was brought into the state system. And at that point, I thought it, was unfair, and I know that the powers that be in the public advocacy world thought that it was inevitable that Louisville would be brought on. So I was looking for a time, but when it wasn't right, I wasn't going to push it, looking for a time to finally bring Louisville into the system. As we've mentioned, it's a state responsibility. And so the question is, why now? Well, there's a number of reasons. One is the recent Department of Juvenile Justice issue has brought this back up to my mind, where the DJJ is a state responsibility that only Louisville was paying for at the local level, and there's an unfairness to that. But we also had a council hearing recently, Metro Council, where bipartisan support of bringing this office into the state system, and that was at the Louisville Council. And so it's not, to my knowledge, objected to by anyone, it is, including bipartisan support at the local level. I don't know how long, hopefully for a long time, I don't know how long the current public advocate, Damon Preston, is somebody who we all know, and I have a great deal of respect for. I don't know how long he'll be there. And Leo Smith, who's in charge at the Louisville office, I don't know how long he'll be there. But both of them are reaching the ends, I think, of their careers. And I trust both of those men. And if we're going to do it, which it's inevitable that it be done, I think they should be the ones that do this. So what does this do in a nutshell? It sets up a transition period. So the next biennium, the Louisville office will be under the umbrella of the state office, where the state office will be running it just like it does the rest of the offices throughout the Commonwealth. With that, Mr. Chairman, I'm open to any questions.
Is there any discussion among the members? Representative Petrie, you're recognized.
Thank you, Mr. Chairman. We've discussed this before, Representative Nemes, and I would remind everybody that there's another reason for the timing of this bill. Also, last session, House Bill 1, there were emergency funds essentially that were placed in, a little over $6 million, I think, that was placed into the public advocate system, the state system, and that was somewhat on condition that we recognized there needed to be a restructuring. And Public Advocate Preston and other ones have worked with us. We're working on that. We hope to have something ready for this upcoming session in 24, and then we'll have the budget adjust. That should allow us to, if I saw your bill correctly, Section 7 says the effective date is July 1, 2024.
Yes, sir.
So that way we'll be able to complete that adjustment rather than later on having to bring in another entity and hope it fits the right structure. Since we're restructuring now, this is a good opportunity, especially to adjust the budgets. And just in case anyone's concerned, there is a portion of state money that already flows to the separate organization in ways. So this will not be a full-on extra cost. It'll be a partial, but we can deal with it in the upcoming budget.
That's right. The state system right now pays approximately 2/3 of the cost of the office. Yes, sir.
Sure.
That was just my question right there.
Okay. So is there a motion to adopt House Bill 568? A motion by Representative Bray, a second by. Oh, there's a question. Okay. I'm sorry, I didn't see you.
Thank you, Mr. Chairman.
Representative Burke.
My questions are also financial in nature. I'm just seeking a little clarification. So the amount that Louisville was paying previously for this was about $4.5 million. But we know that it will be additional that's needing to be funded by the state in the coming years. Is that sound like the appropriate number?
I don't know what the number is. I've talked to the public defender. I think he's getting us that information. I'm going to go back and forth with him to make sure we get the proper number. My understanding, Representative Burke, is that the state was spending over $6 million, and the county, the city, was putting in 4.5 is what I have in front of me here.
Okay.
And so there will be additional costs. I'm assuming, of course, it's an annualized cost.
Right.
There'll be administrative and so forth and so on to bring them into the system. I don't know the levels of benefits. I understand maybe the Louisville advocates might be getting less of a benefit. They'll become state employees. They're not state employees today. So that's the information that I have. That we do have, I think, a fiscal note that's going to be put onto this that may have been submitted today or going to be submitted today, hopefully. And so we'll know more information then. But I would note that this is a state responsibility, just as it was in Fayette County. And if Jefferson County, for some reason, couldn't meet their responsibilities or decided not to fund this office at all, it would be incumbent upon us under the Constitution that we would have to cover it. So I think it's. Does that answer your question?
Thank you. And I have only one follow-up question, which you've alluded to in your answer. The Louisville public defenders are currently paying into their own pension system, and I'm wondering if there's going to be some kind of credit, or if we've done an actuarial analysis on how to honor the money that they've put into their own retirements when they transfer over to the state system.
And that was one of the questions that I had, and so that's why we're having this transition period to figure all that out. The administrative portions, to make sure who's covering what. Now, I want to be clear that I don't anticipate any Louisville but public defender, just like nobody in Fayette County, would go outside of Louisville. Maybe there's an emergency situation, I don't know, but the intent is that there'll still be the Louisville office just like there was in Fayette. But that's why we're giving it's not 18 months, but 16-month transition to iron all that out.
Thank you.
Thank you. So there's a motion by Representative Bray, a second by Representative Moser. Would our secretary please call the roll?
Representative Banta,
Yes.
Representative Blanton, Representative Bratcher,
Yes.
Representative Bray,
Yes.
Representative Burt,
Yes.
Representative Decker,
Yes.
Representative Dietz,
Yes.
Representative Doan,
Yes.
Representative Flannery, Representative Herron,
Yes.
Representative Kulkarni,
Yes.
Representative Lewis,
Yes.
Representative Maddox,
Yes.
Representative Mosier,
Yes.
Representative Nemus,
Yes.
Representative Petrie,
Yes.
Representative Rawling,
Yes.
Representative Sharp,
Aye.
Representative Stevenson, yes, Representative Wilson,
May I explain my vote quickly?
Yes, you may.
I just want to say I began my career with the Public Defender's Office under Ed Monahan. I only left to work closer to home, and I had no complaints of the office the day I left. I had about every client in McCreary County on the days I had court there, and I always heard everyone deserves their own day in court. I believe it, and so I just want to vote yes.
Chairman Elliott,
Aye. So with 20 yes votes, 0 no votes, and 0 pass votes, House Bill 568 is passed and will be reported with favorable expression.
Thank you, Mr. Chairman.
Congratulations, Representative Nemus. So our last bill, I believe, on the agenda is House Bill 103, and that is Representative Ryan Dotson, and Representative Nick Wilson is standing in for him today, and it's an act relating to the torture of a dog or a cat. And you may begin. Introduce yourself, and you may begin, Representative Wilson.
Thank you, Mr. Chairman. As you said, Representative Dotson can't be here today. So I want to thank you for the opportunity to allow me to present this bill. There was a committee substitute submitted to make just a few corrections.
Okay. Is there a motion to adopt the sub? There is a motion by Representative Moser. Is there a second? There's a second by Representative Banta. All those in favor, please say aye. Aye. Those opposed, no. And the committee sub is adopted.
Thank you, Mr. Chairman. Like I said, I'm happy to present this on behalf of Representative Dotson. This was one of the first bills I sought out when I took office, one of the first things I co-sponsored. I believe I was the first co-sponsor. The bill is badly needed. There is a blind spot that I've experienced when it comes to the laws on animal abuse, where as as during my experience as a prosecutor, we rarely had good options on combating animal abuse behavior. And this bill relates to the torture of a dog or a cat. One specifically, we had a case where a man used an AR-15 to shoot a dog over 30 times, killed the dog. Under current law, that is a misdemeanor. We were able to indict a felony of wanton endangerment because of the dangerous nature of that particular action. However, normally that would be a misdemeanor. And in fact, we weren't confident we would get a felony conviction by jury, so I think he ended up with a misdemeanor anyways. But this bill adds abandonment to the definition of torture, and it's very specific on what constitutes abandonment, and it is quite egregious behavior. It is when a dog or cat's tied up, locked up, stuck, they have no ability to save themselves, and they end up freezing to death or starving to death or a serious physical injury. Again, as a prosecutor, I saw a horse tied to a tree till it starved to death. Of course, this wouldn't apply to a horse, but I mean, it's just terrible things are really happening out there to our pets. I want to make a point that this bill is a collaborative effort. Representative Dotson worked with many groups, including like sportsmen and hunters, and this bill is a compromise for everyone. It has common sense exceptions: hunting, fishing, trapping, humane purposes, veterinary purposes, cosmetics, spaying, neutering, sporting activities like the dog shows, bona fide animal research, self-defense or defense of another or your own pet. I mean, these things do come up, and this bill, it takes that into account. There are many exceptions that are common sense, and there's even a catch-all there at the end. So that's basically what the bill does. It changes torture of a dog or a cat from misdemeanor to a felony. And the way it sits right now is second offense is a felony. And I think that you shouldn't get a free chance to do this. So with that being said, I will be happy to answer any questions.
Thank you, Representative Wilson. There is discussion. Representative Banta is recognized.
Thank you to Representative Dotson and you, sir, for bringing this bill forward. I do have one question. In the bill, the only time something can be called torture is if a dog or a cat is restrained. And aren't there times when, for example, the AK-47 would not be restrained that would still be torture?
No, so torture would include intentional infliction to extreme physical pain, or the restraining is under that. So there's more than one way for that to be. Restraint is not the only way. So an intentional infliction is also certainly torture. This adds the restraining part that was really not clear in previous bills, and in fact, I think current law refers to like adequate housing, and that's up to interpretation. And so this kind of takes away terms like adequate to help that along. So that's why the definition is so precise.
Okay. Mr. Chairman, may I follow up?
Yes, you may.
Thank you. I think this is a good bill. I am going to be a yes. It doesn't go far enough. I literally cannot stand this or any kind of abuse of something that you can abuse just because you can. And I also think that it's a severe sign of mental illness that you would do any of the egregious things that you've even talked about. So I'm going to be a yes today, but I say let's keep going. Let's get them.
I agree, and I think we just have to start here. This bill has failed for years and years, and we need a starting point, and I think this is it.
Representative Lewis, do you have a question?
Yes, thank you, Mr. Chairman. Mr. Chairman, I know you mentioned this briefly in your testimony, but in years past, we've had issues arise from this bill brought to us by the houndsmen, different sporting groups. And so just to, again, clarify, there's no groups that oppose this bill, correct?
Not to my knowledge, and there's specific language in the bill referring to hunting, fishing, and sporting activities. They're basically specifically have a specific exception carved out, and to my knowledge, they have no opposition to this bill.
Thank you.
Okay. Is there a motion to adopt House Bill 103 as amended by the committee substitute? Motion by Representative Banta, second by Representative Stevenson. Would our clerk please call the roll?
Representative Banta,
Yes.
Representative Blanton, Representative Bratcher,
Yes.
Representative Bray, Representative Burt,
Yes.
Representative Decker,
Yes.
Representative Dietz, Representative Doan,
Yes.
Representative Flannery, Representative Herron,
Yes.
Representative Cole Carney,
Yes.
Representative Lewis,
I'm going to pass today, but I'll see what it's like on the floor. Thank you.
Representative Maddox,
Pass.
Representative Mosier,
Yes.
Representative Nemus,
Yes.
Representative Petrie, Representative Rawlings,
Yes.
Representative Sharp,
Aye.
Representative Stevenson,
Yes.
Representative Wilson,
Yes.
Chairman Elliott,
Aye. So with 15 yes votes, no votes, and 2 pass votes, House Bill 103 is amended by the committee substitute is passed and will be reported with favorable expression on the floor. That's our last